Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about immigration consequences for criminal convictions. Cases that should have gone to the Supreme Court of Canada, but didn't. Akim Mvana was a citizen of the Democratic Republic of Congo who was convicted of criminal offenses in Canada and ordered to be deported from Canada as a result of those criminal offenses. This is because the Immigration and Refugee Protection Act in Canada defines any offense that is a hybrid offense as an indictable offense, even if it is prosecuted summarily. Mr. Mvana was only convicted of offenses that were prosecuted summarily, and he argued that it was unconstitutional for the immigration officials to essentially, and the Immigration and Refugee Protection Act to essentially say that something is indictable when it, in its facts, very clearly was not indictable, and that this amounted to an unfairness that treated him incorrectly under Canadian law. His application to find it unconstitutional was dismissed. He sought leave to the Supreme Court of Canada, and that leave was denied. And this case does raise very important issues. How can an immigration statute second-guess the discretion that's exercised by Crown in determining how to lay and how to proceed with a charge? Oftentimes, these determinations are directly related to the severity of the conduct. And the provisions at issue in the Immigration and Refugee Protection Act are provisions related to serious criminality. But if the conduct is not sufficiently serious for the Crown to prosecute it by indictment, why would it make sense for somebody to be removed from this country for serious criminality? The biggest example of this that comes up most frequently is people who are convicted of impaired driving offenses. Those offenses are almost ubiquitously prosecuted summarily unless there's injury or death. And so people who are not citizens of Canada all end up facing deportation upon conviction for these offenses on the basis of the fact that they're serious criminality, even though it might be something as simple as blowing exactly the legal limit while proceeding through a roadblock with no injuries. Something that would be in one province issued an administrative suspension but prosecuted in another. And these types of discretionary decisions are dealt with involving summary offenses across the country by Crown Counsel across the country all the time. So the Supreme Court of Canada here had an opportunity to make our immigration statute more fair. It costs taxpayers a lot to subject people to deportation proceedings, and it's unfair to people to not even give them so much as a right of appeal in circumstances where the immigration statute is automatically second-guessing the judgment of people who actually looked at the file and actually looked at the facts and ordering their automatic deportation. This isn't in the interest of justice, and in my opinion, it's not constitutional, and it would have been appropriate for the Supreme Court of Canada to at least chime in on this issue and try to justify why this can be. Hopefully another case makes it to the Supreme Court of Canada, and hopefully sooner rather than later. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.